Hello, my name is Andrew Kinney. I'm an attorney that does Social Security work for DisabilityLawyer.com. Today I wanted to talk about what happens at your Social Security hearing. I've done this work about 20 years. I've done thousands of hearings, but what's important is that if you go to your hearing, it may be the only one you've ever done, and hopefully it'll be the only hearing you ever go to. So my clients frequently ask, and it makes sense that they do, well, what happens at a Social Security hearing? So what I'll do is go through what happens at a hearing, who's there, why they're doing a hearing, and what happens after a hearing. Social Security has hearings because they want to meet you. Now, in theory, a judge could make a decision before the judge meets you by reading your medical records, but ultimately what's important is that your medical records have limitations. Specifically, your medical records don't know how you feel day to day. There may be some symptoms included in the file, but in the end, the only way a judge is really going to know what you're dealing with every day is to talk with you, and to talk with you in person if at all possible. So a Social Security hearing is really, in my book, a meeting with a judge. The Social Security judge is trained in Social Security law. Some have more experience, some have less experience, but in the end, there are a limited number of judges, and there are quite a number of people that need and are applying for Social Security benefits. So when you think about it, a judge is going to meet you for a period of time, perhaps a half hour to an hour, and in that period of time, the judge will be talking with you about what's wrong with you. The idea is that the judge is going to have a limited attention span by definition because they're trying to meet a lot of people. So the goal of your meeting with the judge is to talk directly with the judge about what's wrong, and the medical questions are the most important questions. Who is at your Social Security hearing? Well, the judge, as I mentioned, your attorney, because I would advise that you appoint one, and also yourself. There will be a hearing recorder that records the hearing, but there will also usually always be a vocational expert, a job expert that the government pays to be there, but they're independent. There may also be a medical expert, just like the job expert. They're paid to be there, but they're independent as well. The medical and job experts, what their jobs are to do is go through their background and your particular file and give a summary to the judge as to their opinion. As far as a medical expert, their opinion is what's wrong with you and how are you limited. As far as a job expert, the question is of the limitations that are presented to the job expert, here are the jobs that in theory you could do full time. So you have some experts at the hearings and you have an attorney sitting next to you. So if you picture going to a hearing right now, you'll be going into a private conference room, usually set up permanently, but there can be temporary locations, and your attorney at the front end of the hearing may have spoken with the judge before the hearing, but generally your attorney may be able to give an opening statement as to what law applies, where to look in the medical record, things like that. But ultimately then, if you picture yourself, the judge is going to ask you questions directly. What's wrong with you? Why are you here? What's the worst problem that's wrong with you? If you have physical limitations, the judge may ask about how long you can sit, stand, and walk, what difficulties you have maybe picking things up. In the end, your physical limitations that affect you day to day are important, and you can give examples, especially if the judge asks. The idea is understanding that we know what's wrong with you. We know you have a diagnosis. We see the medical records, but tell me in your own words what's wrong. The job expert will be testifying and generally won't really interact with you. And the job expert is going to take whatever you can and can't do day to day, either physically or emotionally, and the judge will ask the job expert, are there jobs that you can do? The general medical standard for a Social Security hearing is whether you can hold a full-time job, and they don't care about getting to the job. Ultimately, they only care about your ability to do full-time work if you're at a job site, so it's all in theory. They don't care about the economy, they don't care about jobs, whether they're available, they only care that they exist in certain numbers. Your attorney can explain that. But in the end, you're laying out why a full-time job is not possible, perhaps even the easiest of jobs. At the hearing itself, there can be a different order to events, but the general idea is that the judge will interact with your attorney in the front end while it's recorded, swear experts in, including you, and then the judge, and again, this is a general summary here, the judge will usually ask you questions about if you currently are working or when you last worked, and then the judge will get into the physical and mental limitations that you have and how they affect you day to day. Then the judge generally will ask your attorney to follow up with questions, and those questions will get at maybe things that weren't developed fully in your questions and answers with the judge. The judge will then turn, if there is a medical expert, to ask the medical expert, what are the medical problems in this file based on their background. If it's a psychologist as a medical expert, they'll talk about the psychological problems in the medical record. Similarly, if they're a doctor that handles the physical problems, they'll only deal with that. They generally won't deal with both. But the judge will get an opinion from the doctor, and at that point, your attorney will be offered by the judge to do cross-examination. They'll be able to ask questions based on the medical record, hopefully, as to where their testimony came from, and also, in essence, try to rebut maybe negative aspects of the expert testimony. Once that's done, then the judge will go to the job expert and ask what's called a hypothetical question. In Social Security hearings, the basic idea is this: you have a set of medical problems that are defined by doctors, and those defined medical problems cause limitations. Those are the limitations that count. In your day-to-day life, there may be physical problems and emotional problems that affect your ability to do things. What the judge will do with the job expert is ask if someone is limited, namely you, with these, let's say, 10 different limitations, are there full-time jobs that exist to allow for those limitations? How many questions the judge asks is up to the judge. It can be one question, it could be 10 questions to the vocational expert, but generally it's about 3 to 5 questions. Then the judge opens the door for the attorney to follow up with questions. The attorney, in my case for me, I would ask questions about specific limitations that were not included in the hypothetical questions. All in all, your Social Security hearing is an attempt to, one, find out what's wrong with you in your own words, and two, define what's wrong with you in medical terms, and three, find out if there are jobs that are still available full-time for you based on those limitations. Ultimately, your choice in going to the hearing is to have representation or to go on your own. You're welcome to go on your own. It's your right. You can have a friend, family member, non-attorney, or an attorney go with you. My recommendation is this: your hearing is important enough to do it right the first time. The amount of money that you may get going forward from Social Security to live off of and survive on is important enough to invest perhaps a quarter of your back pay to be approved. That's worth the risk. So my advice is to think of these things. You do have a right in your first hearing to ask for a postponement. It's not ideal, but if you decide you want representation, you get to your first hearing without it, you can ask the judge to postpone it once. You have that right, and that is in the regulations. If you have any questions of us, you can go to disabilitylawyer.com and ask us anything you need to. We're here to help. Thank you.